The proceedings.
Straight to and get you to introduce yourselves. And off we go. Ready to go live? Yeah. Order. Welcome to this session of the Justice Committee. The first part of our session is looking at the Post Office Horizon Systems Offences Bill, which is currently before Parliament, in particular the implications that may have for the justice system and the operation of the system. So grateful to our panel of experts who are witnesses to coming to join us. I'll come to you shortly. We have at the beginning of the meeting just to do with declarations of interest. I'm a non-practising barrister, former consultant to a law firm. Simpson.
I'm a barrister with a current practising certificate but not undertaking any direct court work. I'm a former Solicitor General, former chair of CAFCAS, former chair of the National Child Safeguarding Practice Review Panel. My brother is the chair of the Prison Reform Trust, and I'm currently advising ministers on family justice policy.
Right. Joanna. Welcome, Joanna Cherry, who's guesting as the chair of the Joint Committee on Human Rights. Joanna,
Thank you very much, Chair. Non-practising member of the Faculty of Advocates.
I'm a practising solicitor and partner in a firm of solicitors.
I'm a member of CWU, the union.
Communication Workers Union. Thank you. Great. Well, thank you very much for that. Can I just ask our panel of witnesses to introduce themselves? Shall we start remotely with Mr. Rozenberg?
I'm Joshua Rozenberg. I'm a legal commentator and journalist.
Thank you very much. Dr. Quirk.
I'm Dr. Hannah Quirk. I'm a reader in criminal law at King's College London, and I'm editor of the Criminal Law Review.
I'm Dr. Robert Craig. I'm a lecturer in constitutional law at the University of Bristol.
I'm James Chalmers. I'm Regius Professor of Law at the University of Glasgow.
Thank you very much, and thanks for your time. Can I just kick off? It's a rather unusual piece of legislation, to put it mildly, isn't it? It purports to quash a raft of convictions, and I suppose we're going into some of the detail of it in a moment, but I suppose it really raises the first thing around whether or not it's actually going to achieve what it wants to do and what the cost is. Because we've looked at the bill, and the aim is to quash the criminal convictions imposed by the courts, which are said to be unsafe because of the unreliability of the Horizon system and the evidence that was generated by it. Do you think that the bill actually achieves that purpose to start with? It says that Clause 1 says that, in effect, those convictions will be quashed on the date that the bill has the royal assent. Have any of you ever come across such a procedure before?
No, I think
no. I think there's a unit. We're all agreed. This is wholly unusual. Is it justified? What are the risks of doing this? You're shaking your head, Dr. Quirk. Perhaps you tell us why.
Thank you. I'm uneasy about this bill for a number of reasons, largely that Parliament and ministers being involved directly in quashing convictions. I completely understand the sentiment behind the bill. It's been an appalling travesty of justice that the postmasters have suffered, but I think there are very significant concerns about Parliament getting involved in individual cases as it does. I think there's questions about what the status of these convictions. I think you may find people who've had their cases quashed by the Court of Appeal might wonder if there's a difference between their cases being their innocence and also those who've had pardons, how that relates to it as well. So I think the precedent it establishes is my biggest concern.
Anyone else want to add to that point?
I take the opposite view, I'm afraid.
Yeah, tell us why.
I think it's not only necessary, not justified, but actually necessary. I think it's an excellent idea, and it has plenty. I think, well, to take Chitty's point of view, he says a pardon can be granted by Act of Parliament or by seal. So it's Chitty 200 years ago thinks it's perfectly constitutionally proper, and I would agree. It's the idea of as an opening claim. The idea that you exclude some people who've applied to the Court of Appeal, to me, seems to undermine the entire purpose of the Act, which is to wipe away all of the convictions. I say wipe away as a colloquial phrase, from the entire period. And I think that's exactly what should be done in this case, given the situation and I think it's entirely consistent with what the Court of Appeal have said, which is that this is an affront to the conscience of the court.
Court of Appeal relied upon a test in effect whether Horizon was essential to the prosecution case. This is going well beyond that, isn't it? What's the justification for that?
I think the fundamental justification is Blackstone's principle, which is it's better for 10 guilty people to go free than one innocent person be punished. Now, that's a cuddly principle. We all smile and think that's a nice idea. But when now we have an actual example where this systemic level principle is absolutely applicable, and it's not 10 to 1, it's the other way around, it's 1 to 10. So I think it's an open and shut case, really, in terms of I actually think we should lean in and say it's a good thing that some guilty people are going to get away with this, because this is a systemic threat that the Post Office has posed. We've got people in Parliament now questioning the judge's role here. That needs to be squashed quickly, because the judges have got enough to do without second-guessing what the prosecution are up to in their cases. So that's why I think that it's actually we should lean in.
Yeah, I think we got the drift of where you're coming from. Okay, what about yourself, Professor Chalmers?
I would also support the bill. I was somewhat surprised initially in reading it at the mechanism that convictions would be quashed immediately on royal assent, because one concern that does raise is that the public record is by definition no longer accurate. There's a group of convictions recorded as such, but where the record cannot be relied upon. Now, that is remedied in part by the mechanism whereby the Secretary of State is to identify convictions that should be removed from the records. But that exercise will not be comprehensive. It's not the case that if a conviction is not identified as being quashed, it therefore stands. So it does create, I think, an unprecedented situation where there are convictions which are on the public record but which we are not to rely upon, but without a comprehensive mechanism for identifying which ones these are.
Yeah, okay. And Professor Rozenberg,
Picking up Professor Chalmers' point, the point at which the point at which this comes into effect is the crucial point, because, as he says, it will be for the Secretary of State to send a message to the courts to say you must treat this conviction as an acquittal and pass this on to the criminal records people, just as you would with anybody acquitted on appeal. And so he's absolutely right. When the Act takes effect, the records will be inaccurate, and we won't know for a fact who this legislation applies to. But I think I agree with Robert Craig about the general point, which is that this is, as the government says, the least worst option. Their concern for allowing this to go through the courts in the normal way is that a number of people simply won't apply, and if they do apply, these cases will take a long time, whereas the government's position, as you know, is that this will clear everything up. The government intends this to become law by July, and when it becomes law, those people will be acquitted by law, and of course that includes people who've died in the meantime.
Yeah, I understand that point. I mean, it had been suggested, and there's been some evidence given to our committee to suggest that the Court of Appeal could fast-track these cases, and that could be done much more quickly than usual. You'll be a very experienced commentator in these matters, Joshua. Is it realistic that could be done by July, do you think?
The Secretary of State, Alex Chalk, is sceptical. He thinks that cases would be adjourned and the courts would have to accept those adjournments. Some would be done by July. It really depends on what approach the prosecutor takes. If the prosecutor, generally speaking, the Post Office might be the Crown Prosecution Service. We haven't talked about the Department of Work and Pensions yet. If the prosecutor accepts that the conviction should be quashed, well, it will be quashed, and it can be done very quickly, and the courts are very proud of the fact that they have fast-track cases through in those circumstances. But what we're concerned about is the cases where the prosecutor does not accept that these people should be cleared. There may not be very many of those, or, above all, the cases where people simply don't want anything more to do with the criminal justice system and are simply not prepared to allow their names to go forward and appeal. There's also the advantage from their point of view, which is that it won't be necessary for people to tell the world that they were convicted 15, 20 years ago and have now been cleared. Their cases may have been forgotten about by everybody they knew then. This will all be private in the sense that they will have access to criminal records. They will be able to show anybody who needs to know that they've been cleared, but the whole publicity surrounding them will not be brought up again by the fact that their case comes before the courts and they will be named in court. Some people may want that, others may not.
I don't know. I mean, as a journalist, you may have been able to look at this in more detail than some of our academic witnesses. Has anybody been able to quantify how many those people might be? I mean, you make a fair point. The Secretary of State has said there's a lot of people are not engaging. That will be right. I'm not sure if anyone's been able to put a figure on what that is.
It's about
I agree. I think the only information we have is from the Criminal Cases Review Commission, which has certainly been advertising, because it certainly hasn't had as many people coming forward as were involved in the Bates litigation.
Dr. A, do you have any more on that?
Just on the Horizon Compensation Advisory Board with Lord Arbuthnot and various Chris Hodges and people have suggested that have recently stated that the Post Office say that they are duty bound to oppose something like 330 of these appeals, which means they still don't get it. And the reason is because they seem to think that they're private litigators, that they think they have to fight. They actually think they're going to be in contempt of court if they don't fight. In other words, they're not thinking like public prosecutors. This is 3 months ago. So they still don't get it. That's another reason, I think, for pursuing this approach.
Dr. Quirk.
One slight concern with almost forcing an acquittal on people. When we looked at other or previous systemic miscarriages of justice, such as the West Midlands Serious Crime Squad, there were people who'd been wrongly convicted who did not want to go back to that issue because they had, for example, a new partner who they hadn't told. So there may be, I appreciate the point about it's not made public, but there may be personal ramifications.
Okay, I understand that. Yeah, Mr. Daly.
Just one very quick question. I'm sorry, it's a very obvious question. I think looking at the bill, the start date for convictions is the 23rd of September 1996. Could you just confirm why it's the 23rd of September?
There was a pilot program. There was a pilot program that ran out, and the date, and so that could capture some people whose situation were before the main rollout.
And just there are obviously lots of post office prosecutions prior to that day, but the logic being that none of those involved the Horizon scheme.
That's the idea.
Thank you. Sorry, Chair. Thank you.
Now, I mean, given that we are in a situation where Parliament, without a division, passed the second reading of the bill, whatever we think about the principle of it, it's got this far, and we can debate the merits one way or the other. Is the bill we'd like to explore a bit going to actually do the job adequately? So, for example, Clause 2 sets out 5 conditions that must be satisfied before the conviction is quashed. Are those conditions sufficiently tailored, do you think, to meet the justice of rectifying a wrong that everybody accepts has been done in this case? Are they adequate? You think they are, Dr. Quirk? Or any bits where you think it could be improved, for example?
I do. I wondered around Section 3 whether we needed to look at magistrates' courts cases. And there's also a case that the Criminal Cases Review Commission has just referred. It wasn't sure if it was able to or not, where it was a magistrates' court plea where the defendant has died. And there isn't really a mechanism for referring those cases. So I think they've referred it anyway as a punt. But that might be worth something adding into the legislation so that they have that power then in future cases.
We all know that there is a mechanism where the Criminal Cases Review Commission can refer the convictions of people who are deceased.
Only to the Court of Appeal.
Only to the Court of Appeal, but you can't do it on the magistrates. Yeah. Okay,
so that might be worth
that's the gap.
Statutory amendment.
Okay, that's very helpful. Okay, any other observations on the conditions in Clause 2? Okay.
Joshua Rozenberg.
Yes, Joshua, thank you.
I was just going to say they go much further than the Hamilton case, don't they?
Yes, they do.
They're much broader. And you can see the government's intention. The government doesn't want any officials in Department of Work and Pensions to have to consider whether a specific case referred to it comes within what will then be the Act or not. And so it's tried to draft these very broadly. But of course, there is still the question about whether prosecutions by the Department of Work and Pensions should be brought into scope.
Yeah, no, that's a fair one. As you say, the test in Hamilton was really whether or not the Horizon data was essential to the prosecution, and this is more broadly, and Parliament is entitled, if it wishes to go more broadly than the Court of Appeals ratio. Professor Chalmers.
Perhaps just on that, one difficulty which will arise in some cases is the sheer paucity of information about whether Horizon data was or was not essential. So one of the appeals in Ambrose, for example, was allowed solely on the basis that there was a line in an internal spreadsheet in the Post Office saying this was an audit case. Often with these cases, there simply are the records held anymore, they're certainly not comprehensive at this point, and therefore requiring a demonstration that the evidence was essential in the category will be problematic.
Okay. And finally from me, but other colleagues will come in, the explanatory notes around this section, so that the criteria set out in the bill are intended to be unambiguous. Is it unambiguous from your point of view?
There are bound to be borderline cases, aren't there? There are bound to be cases where officials are going to have to take a decision and make a recommendation to the Secretary of State, who has the power to give effect to what Parliament will have decided, because if the Secretary of State is not persuaded to inform the trial court, then the conviction won't be publicly quashed.
So the suggestion that this is intended to be done without anybody having to apply judgment can't really be right, can it? Somebody's going to have to apply some judgment somewhere.
But the beauty of the time-based analysis is the beauty of the time limit is that it's about as clear as you're going to get, which I think is a good thing.
Okay. Any other thoughts around ambiguity, Dr. Quirk?
I just wondered why there's a reference to the compensation scheme under the Criminal Justice Act of 1988 when these cases were all being dealt with under separate compensation
Under a
schemes.
separate provision, yeah. Okay. And that's not clear as far as we've seen so far. Okay, that's helpful. Dr. Mullen.
Just furthering the discussion of the ambiguity element, and as you said, if you make it essential, that's quite challenging. But in the other direction, given that someone will have to go through the cases just to check the bare bones of it, do you think it would be impossible to have, somewhere that's between essential and potentially no reference to Horizon whatsoever in a conviction, where you could at least say it's mentioned present part of the case in some manner at all, or you would agree with the government's position that even that would be too complicated to do and not feasible?
I think I would agree with the government's position there, and I'm not in a position to speak to the detail of this, but I would have thought most cases would involve some mention of Horizon, in the sense this was the primary means for keeping records.
Well, just to give you an example in theory to help the discussion, if, for example, you were seen taking money out of a till, I mean, Horizon might literally have no bearing on the case in any way, shape or form. It shouldn't be mentioned in any way, shape or form. That might be an example.
It might be an example, but I would have thought in that sort of case, I may well be wrong, that there would be some mention in the papers that were available of the records on Horizon, because this is the record-keeping system. So I can't clearly identify any sort of test that would allow you to distinguish cases that you would quash from those that you wouldn't.
Okay. Anyone else feel differently?
I don't feel differently. I think it's a bigger picture, which is even those ones need to be quashed, because it's got to send a message to the post office and message to the future. And the actions of the post office for the last 20 years is going to be used as a case study across every Westminster system forever. That's the reputation that this generation have imposed on the post office.
Dr. Quirk.
I disagree, but I think it possibly wouldn't be an issue because they're not carrying out, if they're taking money out of the till, they're not doing so as part of their functions as a postmaster. So I think you could exclude it that way.
Okay.
Okay. Raises an interesting thought. If you're behind the till in consequence of your work as a postmaster, aren't you then, and you then pocket it, aren't you then carrying that out in the course of your employment as a postmaster?
I think the answer is yes to that, because condition C is that condition C is that at the time of the alleged offence, a person was carrying on post office business, or was working at a post office. So even if they were, taking cash out the till, they would still be doing that as a postmaster rather than a walk-in thief.
You're saying that the moment that they steal it, they cease to be active in the course of their employment, in effect?
Well, I think there's a difference between taking money out of the till to give somebody their change and taking money out of the till to... You're not doing that as a postmaster.
Doesn't this discussion just illustrate that there is ambiguity? I mean, it's a bit of an old chestnut, isn't it? Whether if you do something criminal in the course of your employment, whether you're doing it in the course of your employment or whether it's so extraordinary that it's removed from the course of your employment. That's a debate that's gone on in all sorts of spheres of law for quite a long time. I'm afraid I'm not quite sure what the outcome is on it,
I think that's absolutely right, but I don't think that is the condition C test. I think the condition C test is simply were you employed for working in a post office, not whether you were in the course of your employment.
Exactly,
but D,
that's right.
I'm thinking about D, where the alleged offence was committed in connection with running or working for the post office business. That's where the potential ambiguity is.
I think in connection is rather different from course. I see the point, but I think it is rather broader than course of employment.
It's clearly a broader phrase.
In connection is broader or narrower than course of employment? See, I think it is a bit ambiguous.
Yeah. It's a different circumstance. It'd be interesting if it was tested in court, but I'm not sure if it...
And the civil servant's going to have to actually
some discussion,
do something about distinguishing them in some way. It's not a complete blanket.
Okay. Anything else? I suppose the Lord Chancellor at one time talked in terms of an approach for it's all the fruit of the poison tree. Would it be simpler and easier perhaps to have adopted that approach? To say that it's all tainted if it's come via the Post Office as prosecutor.
But can I just develop that point? Because that's why I asked the question about the 23rd of September 1996. Because if it comes down to, forgive me, I'm going to, if it is a question of the reputation of the prosecutor, then every single prosecution that the Post Office has ever brought under any circumstances should be quashed on that logic.
Yep.
I think the Horizon system is, because they look at the numbers jumping at the time that Horizon was rolled out, there was a step change. So that's a really easy break point that you can go before that. We can't be sure, but we're going to let that go. But from the point that this system came in, the culture curdled and it became a different kind of beast that was going on. And that's the point at which you should move
But
forward.
are you comfortable with, if you had the misfortune of being in court on the 17th of September 1996, having done exactly the same thing as somebody who was there on the 30th of September 1996, are you comfortable those two people should be treated differently?
I think we have to draw a line somewhere, and I think the line is
Why is
the
that?
line I would draw there is because that's when their culture changed. Internally, that's when this curdling, the curdling I call it, of the culture, whereby it became about sort of as if they were trying to. It was malicious prosecutions, and I think that's when it kind of started. And I don't think we've got evidence that there was that culture before, and that's sufficient for me to draw the line there.
I think this is one of the difficulties with the status of for the postmasters as well, because I understand the sentiment of we just clear everything out and say all these convictions were wrong, and so be it. If some guilty people get a bonus, but then I think there's a danger that then taints the acquittal of all the postmasters who quite rightly say I was completely innocent of this. So I think, despite the good intentions of the Act, I think there is a danger of devaluing what's being done for individual postmasters here.
One of the things this committee deals with all the time is things like IPP and things like this. So if you talk about retrospective legislation, the danger always is that people are treated differently. And as far as I can see, the only explanation, which is not, I'm afraid to say, Dr. Craig, not the most convincing explanation, is that as a result of a computer system being installed, that means that all these cases must be treated differently to all these cases before. I can't see, if you're going to retrospective legislation on the basis of the logic that you've put forward should apply to every single case the Post Office has ever put forward. Surely, it has to.
Come to that, which is that there are two categories of abuse of process.
Yeah.
Category one is when there's a relationship horizontally between the prosecutor and the defendant that's an abuse and needs to be stayed. This has been found by Lord Justice Holdroyd in Hamilton to be a category 2. That's an abuse to the conscience of the court. And that becomes a systemic problem. And when it's a systemic problem, you need a systemic solution. And that's when principles like Blackstone's principle kick in. When you have to say, this is all wrong. And they have to send a message that all of these prosecutions, because of this prosecutor, and that message needs to go forward in the future as well. So I think there's a systemic difference, and that systemic moment is when the prosecution stops acting on the duty of with their overriding duty to the court, and starts being about horizontal attacks on people who are innocent.
Do you want to follow on?
I think there are dangers with that. As I said, when the Court of Appeal has looked previously at systemic wrongs, such as the Serious Crime Squad cases, it hasn't just blanketly quashed everything. I think there are also, as you said, dangers with the retroactivity of it. You could quite easily see a scenario now where people who are convicted in Northern Ireland under emergency provisions legislation that have subsequently fallen foul now say, why shouldn't my convictions be looked at too? Or people who've received pardons, the Alan Turing legislation or the First World War cases, why are we being treated differently? This was a systemic abuse of our rights too. So I think there are dangers, despite the government having said this isn't intended to be establishing a precedent. I think it would be very difficult to argue against it.
Any other observations on that point? I'll move to Ms. Hopkins.
Thank you, Chair. just going back to Clause 4, we touched on it slightly, and Clause 4 of the bill requires the Secretary of State to take all reasonable steps to identify convictions quashed by Clause 1, and the Secretary of State must then notify the relevant court of these convictions, and most importantly must then notify the person or person's representatives that the conviction has been quashed. Can you elaborate on any potential practical difficulties that you see with that approach for the Secretary of State in taking steps like these?
I suppose it's simply initially the state of the records that are available for this. You know, obviously, this is not directly relevant here, but we know it in Scotland from statements with the Lord Advocate. Essentially, all cases in this period are now past the period for routine destruction of case files. Now, they have been able to get material in Scottish cases from the Post Office, and the Post Office does seem to have kept things longer. Whether it's kept them systemically would be a different matter. So it's simply identifying the cases that are concerned with what the facts of those cases were, insofar as the relevance to the various conditions, is going to be challenging. And I imagine that tracing the individuals concerned in some cases will be very difficult as well.
I'm sure that's right.
Yes.
If I can come in there, I'm sure that's right. I think this is the most difficult part of the bill in deciding which cases are covered. Now, in one sense, it may not matter too much because the government can say, well, these people who are covered by this bill are cleared whether they do anything about it or not. If they want to prove it, if they want to get a disclosure and barring service, clear declaration, then they go through the process of telling the Secretary of State. And of course, they can make representations, and the government has to listen to any representations made on behalf of anybody, by anybody, in reaching its decision, and maybe it could even be challenged by judicial review if the Secretary of State declines to sign, to find that somebody comes within the categories. But it is very tricky, and it's going to be imperfect. And I don't think anybody's suggesting that all the cases which are covered by what will be the Act will actually be referred to the various courts. It is quite messy, but on the other hand, unless you actually are going to publish a list of everybody who's cleared, a statutory instrument, I thought that was one way the government might go through it. Unless you're going to do it that way, you've got to have some way of establishing who actually comes within this legislation, given that nobody is actually going to be named in the Act or any secondary legislation.
Can I come back to Dr. Quirk?
Thank you. I wonder if a possible compromise might be, rather than the Secretary of State doing it, asking the Criminal Cases Review Commission to do it, as it would then slightly distance the referral mechanism from the executive.
Can I just press ahead with a couple of those nuances that have been picked up already? Talking about who will be responsible for administering the scheme, and your suggestion actually is CCR to sort of take that step back. If there are disputes, and that's a point raised about whether a conviction has actually been quashed, how should the Secretary of State handle that? There was a suggestion there about JR, but I don't know if anyone's got any views about that sort of dispute.
I suppose
it's really
Yes.
Sorry. Go ahead.
Joshua, yes.
Okay, it's really a question of what guidance officials are given by the Secretary of State, isn't it? Do they err on the side of including people, as Robert Craig argues, or do they try and save money, which what every department would normally want to do? So I think we can it's reasonable to expect the government to tell us what sort of guidance will be applied when officials are going through all these cases.
Yeah. Okay.
Just a final point, sorry. We talked about whether people in practice, those who've been affected by the Horizon scandal, could they just consider their conviction to be quashed? They can't consider their conviction to be quashed until they receive that notification by the Secretary of State.
That's not right. They can consider their conviction to be quashed as soon as the Act achieves royal assent. The problem is proving it, and they can't prove it without some notification from the Secretary of State. But yes, they can say, they can celebrate on this day in July that their conviction has been quashed because they will know, they will be confident that they come within the wording of what will then be the Act. But how you persuade others is the problem that we're talking about.
So what we need is some process whereby someone can prove, let's say, to the visa department at the American embassy, if you wanted to go there, or to a potential employer, I am one of the people whose conviction has been quashed by this. And we don't seem to have that mechanism spelt out at the moment, do we?
I think we have that mechanism in the sense that once the Secretary of State has asked for the information to be deleted from the records, as it were, then any criminal record check is going to come up without that information. So that, I think, is the mechanism. But people may, of course, only run up against the need to actually request it be invoked at the point when they're being denied a visa. I think it's maybe worth noting as well that there is some prior experience in operating this sort of system in a slightly different way under the Protection of Freedoms Act, where requests can be made to have a conviction disregarded for historic same-sex activity. So there is experience within the government in processing applications. The difference there is there had to be applications, that was not automatic.
Yeah, I understand that.
And if you wanted an example from the beginning of an Act of Parliament doing something very similar to this, because it was treated as if it had been, that exact act is a good precedent.
Example. Okay.
Can I just mention Clause 4, subsection 4, where the Secretary of State identifies that a person's conviction has been quashed, the Secretary of State must take all reasonable steps to notify the person. So you would get a letter from the government saying your conviction's been quashed.
And you'd show that perhaps to the person.
I presume this only deals with people who haven't got in touch with the Secretary of State. So those who are involved in the process at the moment, they will have given their details beforehand. So they'll be in a position to get letters quite quickly.
There's probably means of dealing with it. That's helpful. Dr. Mullen, thank you.
Just to jump back slightly to clauses 1 and 3 about those that have, and as you might expect, those that probably felt strongly that they had a good case, gone to the Court of Appeal, and the way in which this Act excludes them. I just wonder whether you think that's fair and justifiable. Begin with Dr. Quirk.
If we're taking an expansive approach, then it seems unfair to exclude them, because the Court of Appeal may have been applying different criteria at that stage.
Yes.
The full extent of the scandal hadn't come to light. So
well, we talked earlier, their test was that Horizon was essential, and this test is just that you worked in a post office when Horizon was operating, a vastly different test. I don't know if anyone thinks it is reasonable. Wants to add?
No, I would also think it's unreasonable. I can certainly see the argument for cases from Hamilton onwards, but if somebody had appealed at the time when the problems with Horizon were not documented, it seems to me to be entirely unfair to exclude them from the Act on that basis.
The CCRC has to assess whether to refer, and those people who didn't pass that threshold to be referred are going to get a quashed conviction, and the people who did get referred are not, which seems to be a bit unfair on the people who were close to the line and didn't get it, and the people who didn't make that but low bar aren't going to get quashed.
Does anyone want to play kind of devil's advocate for the government? What do you think they're trying to achieve in doing this?
They're trying.
Dr. Rozenberg.
They're trying not to trespass on the territory of the courts. They're trying not to tread on the judges' toes any more than is necessary. And they've taken a policy decision that where a court has looked at a specific case and decided there was dishonesty, there is evidence of dishonesty apart from Horizon, we shouldn't interfere. But that's a policy decision, and that may be wrong given the broad thrust of the legislation.
And the reason it's wrong is because it's a contested view of the separation of powers to think that it's a pure separation of powers in this country, that we have institutional silos and there shouldn't be overlap. That's not our system. Our system is partial. It's all about checks and balances. This is a paradigm example of Parliament acting correctly under our system to step in and fix a mistake in the common law. And the fact that it should fix it in a generic and as broad a way as possible is because legislation is supposed to be that way. So that to that extent, it's entirely reasonable. But the idea that this is a breach of separation of powers is not one that I share.
Thank you.
Thank you very much. Ms. Cherry and then Mr. Stevens.
Thank you, Chair. The bill only quashes convictions handed down in the courts of England and Wales. So if you are unfortunate enough to be convicted in Scotland or Northern Ireland, your conviction won't be quashed by this bill. My question there is, has the UK government taken the right approach by not extending this bill to Scotland and Northern Ireland? And I might start with Professor Chalmers, if I may.
My view would be no, simply from a practical point of view, given that the Scottish Government has indicated it intends to mirror this legislation, it's very difficult to see how the Scottish Government could make different policy choices to any significant extent from those set down in the bill, given the imperative of quashing convictions as quickly as possible, which underpins this. Requiring the Scottish Government to wait to see how this legislation passes through Parliament, how it is amended, to then try and mirror that later on seems to me to help no one really. I can see the argument, which I think has been made in the Chamber, that the Scottish Parliament can, of course, pass legislation very quickly if it has to. But it would be better, I would have thought, to ensure that there was proper scrutiny of the mechanism within the Act for doing that, if it wasn't being forced into making the policy decisions in a single day, which, of course, it can do if it has to.
I mean, there's been, you'll be aware, there's been a lot of lively discussion in legal circles in Scotland about alternative ways of approaching this. And I think it's fair to say when the Lord Advocate made her statement to the Scottish Parliament, she favoured a more separation of powers approach than perhaps politicians have decided to go down. And I take on board everything Dr. Craig says about that. But what I'm interested in is another proposal that was put forward by somebody which you're probably aware of. There's been a letter to Scottish Legal News from our retired Sheriff Kevin Drummond, KC, who had said that he felt that this matter could be solved tomorrow, not just by the Crown Office and Procurator Fiscal Service in Scotland, but also by the CPS in England, by each agency bringing to their respective criminal appeal court a list of convictions with case references and informing the court that investigations had revealed these convictions to be flawed and inviting the court to overturn these convictions. And he said such a step would have the additional advantage of respecting the separation of powers. Now, I'm not an English lawyer, so I'm not sure how that would work with the CPS, but I wondered if he was talking about the Lord Advocate inviting the Court of the High Court of Justiciary in Scotland to exercise its nobile officium, its kind of equitable power to right wrongs. Did you think that's what he was getting at? And I just wondered what you thought of that proposal.
I think what he was getting at, though I'm not entirely certain, was the ability of the Crown to essentially indicate that it does not oppose an appeal being granted. The limitation of that, I think, is that it has to operate in one or two ways. Either it happens after an investigation, which is not going to be immediate. The Lord Advocate would require a considerable amount of time, I think, to make that judgment as to whether or not the convictions were ones that could be sustained. Or it happens on a basis which is not related to the individual cases, and Lord Advocate simply says, here are the cases of conviction which resulted from reports from the Post Office, please quash them all. I'm not sure the court would think it had the power to do that. And I think the problem beyond that, which I think goes back to a point Dr. Quirk made earlier, is that it may undermine the quashing of convictions if it's believed that there actually has been no consideration of the merits and no criteria applied beyond it being a Post Office case.
I think also you said there earlier that the Crown may not actually have access to the relevant paperwork, so they might not be able to identify the cases.
Yes, I think the Lord Advocate has said that Crown Office has had to obtain information from the Post Office in order to establish what has happened in many cases. What I don't know is whether it is always possible to obtain that information or how comprehensive it is.
I wonder what our other witnesses think about the decision to restrict the bill's application to England and Wales.
I don't have much to add, except, and it's purely as a non-Scottish lawyer, my understanding is the Post Office didn't bring the prosecutions in Scotland. That's an interesting difference for me, speaking, given what I've said today.
I think there may be difficulties, partly sort of logical difficulties, like Northern Ireland comes under the remit of the Criminal Cases Review Commission, whereas there's an argument that Scotland is so separate it should be dealt with differently. I think smaller jurisdictions probably are able to deal with the caseload more quickly. In terms of getting the case back into the Court of Appeal, it would more be a CCRC referral rather than the Crown Prosecution Service in England. I'm not sure of the Scottish distinctions. But again, I think particularly with Northern Ireland, there might be problems with bringing up these ideas around retroactive quashing of convictions, particularly following things like the Legacy Act, which has precluded so many other ways of dealing with conflict-related cases. It might be putting them in quite a difficult position.
That's a very interesting point. Joshua?
I don't want to stick up too much for the UK government, but I would have thought it reasonable for the UK government to expect that the Scottish government would want to handle this itself in its own parliament. So it's slightly unusual for Scotland to be saying to the UK government, well, will you legislate for us? But if that's what Scotland wishes the UK government to do, you would have thought the UK government would be happy to amend the bill in that way.
Can I just quickly go back to Professor Chalmers, if I may, Chair? The point that was made there by Dr. Craig, absolutely correct, of course, that in Scotland these were not private prosecutions. They were pursued by the Crown. Do you think that makes any difference to the legislative approach? Or should it, rather?
I think it shouldn't, because I think what the Scottish experience shows is that the problem was not simply one of the Post Office as prosecutor, but of the Post Office as investigator, because the Crown Office for some time was relying on what it had been told. It regarded the Post Office as one of the longest standing specialist reporting agencies. And I think there is a cautionary the suggestion has been made that actually what this shows is there's a problem with the English system of private prosecution. There may or may not be such a problem, but requiring prosecutions to go
thanks, Professor Chalmers. Actually, the best argument surely is the current criminal justice bill that's going through Parliament just now, in which the Scottish Parliament has given legislative consent for the parts of the criminal justice bill down here that apply to Scotland. And so would that not be a better way of addressing this issue for people in Scotland? Because the issue is basically at the end is to ensure that people are getting compensation at the same time, and the people in Scotland and Northern Ireland don't have a delay in getting that compensation when people in other parts of the UK receive that compensation.
I don't think, although I haven't seen recent figures, that legislative consent motions are that unusual. I wouldn't regard it as exceptional for the Scottish Government to consent in these circumstances. I think the practical reality is that I can't see that the Scottish Government has very much room for manoeuvre on the policy here, because it would be very odd, given the way this links into a UK compensation scheme and not a devolved scheme, if the Scottish Government were to say, we want to do something different in terms of the scope of quashing of convictions. Now, of course, if it did, that would be a different matter. But in a circumstance where it's saying we want to mirror what is happening, but we therefore have to delay it, despite the imperative to try and get this done quickly, that seems to be problematic. I would say, where it's been suggested in the Chamber that one reason for asking the Scottish Government, Scottish Parliament to do this is that there has to be a level of scrutiny of the Lord Advocate and the Scottish prosecution system. But at the same time, it was being suggested, well, the Scottish Parliament can legislate very quickly, and the 3 days was mentioned. Now, you can't have both. You either have the emergency legislation, or you have the detailed scrutiny. And either of those, I think, are valid arguments, but they don't work in conjunction.
The scrutiny of the prosecution could happen after a bill was passed anyway. That's another issue. The issue is to quash convictions and to get compensation to people, isn't it?
Absolutely.
You might be aware, Professor Chalmers, that the Scottish Criminal Cases Review Commission has been actively trying to contact people. Was actively trying to contact people to appeal, but hadn't heard from the majority, although more than England. So does that raise a potential concern that the Post Office may not cooperate fully with the Crown Office and the Scottish Government, particularly given the reticence and the intransigence we've seen over the entirety of this situation?
It may do. I think it's fair to note that in the Court of Appeal judgments, there have been, unusually perhaps, quite complimentary words said about the Post Office and the Post Office's lawyers in terms of bringing forward relevant information, making concessions where appropriate. I'm aware that that's not an experience replicated across this whole sphere, but in terms of dealing with the criminal appeals, those more positive comments have been made. I suspect more generally there is just considerable difficulty in contacting people who may wish to have moved on long after the event, who may not readily be contactable. And there has been a policy decision taken with this legislation that actually there should be something done about the fact that people do not want to come forward and their conviction should be quashed, whether they are asking for that to happen or not.
Does that also potentially impact on family members? I'm thinking about people who are no longer alive.
Absolutely, yes.
Okay. Thank you. Thanks.
Can I just come back
sure.
on that, Professor Chalmers? I just want to understand this properly, because I think you've made a very important point there. I think what you're really saying is, because this bill links into a UK-wide compensation scheme in relation to a UK-wide problem, which is this problem that arose of this malfeasance in the post office, then the Scottish Government is going to have almost identical legislation to fit into that. So it makes sense for there to be UK-wide legislation with a legislative consent motion, which, as you've said, is not something that's necessarily unusual.
Absolutely.
I mean, is it fair to say from time to time people like myself get terribly excited about legislative consent because we think where it's been withheld but it's been ignored, but in actual fact a huge amount of cooperative work goes on between the UK government and the Scottish government where legislative consent motions are made and people like me don't get excited about it. So you're saying this is really just a very practical example of where this legislation is designed to right a UK-wide wrong and to feed into a UK-wide compensation scheme, so it makes sense to have UK-wide legislation.
Yes, I would agree with the point about this being a matter of normal cooperation. My recollection at the time of the Scotland Act was that the mechanism of legislative consent motions was seen as something that would be a bit exceptional, and actually over time it was seen that it was a practical solution to cooperating and ensuring smooth running of the process, and not in most cases contentious.
Thanks, very clear.
Did you make one around that?
Just very briefly, I wondered if one way around this might be uncoupling the compensation from the quashing of the conviction.
Yep.
If we're saying everybody who was convicted is eligible for compensation, that could surely go ahead, and then by whatever mechanism.
Before, and then do the convictions afterwards. Okay. Understood. Okay. Thanks.
Thank you very much, Chair. Can we just go back to the exceptional nature that the government bill is proposing? And I was interested in particular, Dr. Craig, what you quite effusively said about the approach that's been taken, and have cited sort of in evidence of this approach that this isn't a new departure for Parliament in overturning a judicial decision, and I think cited the Burma oil case when there was compensation for the damage caused by British soldiers on retreating, and that led to the War Damages Act of 1965, and that was retrospective, albeit it wasn't a criminal case. So bearing that in mind, how high a bar do we think that needs to be reached to make this exceptional, bearing in mind there have already been 71 convictions quashed by the Court of Appeal, and the fact that the Lady Chief Justice in the most recent case in Falcon in February said, quote, "The court has been and remains committed to the efficient and swift dispatch of Horizon appeals."
I mean, in terms of a precedent, Chitty says a pardon may be effectually granted either by Act of Parliament or under the Great Seal. So in terms of precedent, that's not even a controversial position.
But that's a pardon.
No, I know, but the statutory pardons, if you also look at Chitty, are indistinguishable from Acts of Parliament in their effect. And I don't think we should get too hung up about whether or not a conviction is technically removed or not. I think that's a narrow distinction that doesn't really help us. And so Chitty says, generally speaking, it puts him in the same situation as which he stood before. Insofar it makes him a new man, so as to entitle him to bring an action against anyone who scandalises him in respect of the crime pardoned. So I don't think we want to get too hung up on the narrow distinctions between whether it's a technical quashing or a pardon in this situation. But in any event, the King's right to pardon and remit the consequences of a violation of the law, says Chitty, is confined to cases in which the prosecution is carried on in His Majesty's name. So you can't even pardon these because they're not brought by the King. So the only route open to these people is this.
Is that last point right? Because at
That
the
is-
end of the
that
day,
is
whether
what
it's a
Chitty
private
says.
prosecutor or not, it appears on the indictment as the King against, or the Queen against XY. All prosecutions are brought in the name of the monarch, surely, regardless of whether it's the Crown Prosecution Service or a private prosecutor. Is that right?
my understanding, I'm not sure what the actual indictment said. That's a very good point, Sir Bob. But Chitty is clear that if it's a private prosecution, it's not open to be pardoned. Which means that before the critical the CCRC was got the power to do this, your only remedy was to go to the Court of Appeal again, where the burden of proof is reversed. And if you haven't got evidence to undermine it because it's been destroyed, what the only remedy is an act of Parliament.
The record, can you just tell us who Chitty is?
Oh, I beg your pardon. Chitty is written.
Chitty. No.
A treatise on prerogatives, 1820. So it's hot off the press.
I thought it was Chitty on
explain for the record why you rely on quoting that.
Because he's the leading writer on prerogatives, and he's got a section on pardons.
I think Dr. Quirk just wants to come in.
Yeah, I'm not sure that's completely right. There was the Michael Shields case, who was the Liverpool fan who was convicted in Bulgaria. So that was a foreign jurisdiction. He was convicted.
It was dealt with by Parliament. Is it dealt with by Parliament?
May I check?
Okay.
I think it may be worth noting as well, just to answer the point you asked earlier, it was noted in the Hamilton appeal that the prosecutions were all brought in the name of the Crown, although they were private prosecutions.
I think it's come to the point. Joshua, do you want to come in? Sorry.
Yes, can I pick up a couple of points that were just asked? I don't think we should be too hung up on the idea of this legislation being a precedent. Yes, in political terms, once this is through, as Dr. Quirk says, others will say, me too, please. But it's not a precedent in the legal sense. And the very fact that this legislation is before Parliament for the first time, I think shows us that you don't need a precedent to actually do something for the first time, and the fact that you've done it before doesn't mean you have to do it again. And in terms of Parliament overturning decisions of the courts, we've got much more recent and current examples of that than Burma Oil. I'm not just thinking of the Safety of Rwanda Bill, which says the courts must conclusively treat Rwanda as a safe country, which was not what the Supreme Court found last November. I'm thinking more of the Litigation Funding Agreements Enforceability Bill, which was given a second reading by the House of Lords yesterday, and as the Minister said, it restores the law to the position it was before the Supreme Court decided the Packard case last July. And so we do see examples currently of Parliament overturning decisions of the courts, and maybe this is just another one of them.
Okay. Can you put something out now?
Can I just come back to that question? And it's understanding the consequences of the parliamentary intervention, if you like, in a judicial decision, and whether by taking this route, albeit in the exceptional circumstances that we all know about, that although it may not have sort of a legal precedent that is consequential on that decision, it may encourage others to use a parliamentary remedy rather than a judicial remedy in the future. Is that something that we should factor in and potentially be concerned about?
I think it's a good thing. It's a political constitution that we want to reduce the people's desire to go rushing off to the court. Take your remedy to Parliament. In the political constitution, this is to be encouraged. So the idea that this is somehow a difficulty or a bad thing, that there's going to have more political discourse, more political applications to MPs to fix problems, good.
Does Joshua want to come back? His face suggests he wants to come back.
I don't really know what to think about that. I can see the arguments on both sides, but I don't see why Parliament shouldn't be flexible. And just as the courts very often say this is not a matter for us, it's a matter for Parliament, I do think to some extent, I agree with Robert Craig, Parliament should be encouraged to deal with problems as they come along, and if Parliament thinks the courts have got it wrong, Parliament should be there to put it right.
Dr. Quirk.
Profoundly disagree. If we look at the reasons for the separation of powers, we should not have Parliament acting to convict individuals or to direct. They shouldn't be acquitted. The rule of law needs to apply to everybody, and if you have a situation whereby Parliament can suddenly say, oh, but not to you, we're going to quash those convictions, that's fundamentally deeply dangerous in a democracy and to public confidence in the law. We also don't want to have it reliant on public opinion, because certain cases, I think everybody has the utmost sympathy for the postmasters. What about school teachers or scoutmasters who've been wrongly convicted of historical sex abuse cases. That's a very difficult case to make publicly, and it would be more difficult for politicians to associate themselves with. The whole point of the law is it's not a popularity contest. The law applies to everybody and is applied by the courts in a disinterested way.
I'm not saying that this should be done willy-nilly. I mean, when the qualified criteria might be that it's the greatest miscarriage of justice in the history of UK, then that might be a
just conscious that we have another panel to get on to before we finish this, so I want to make sure that we cover any remaining issues. Remember Mr. Ali first, and I'll come back to other members before they get. Mr. Ali.
I think the issue of precedent's been mentioned before, but the explanatory notes to the bill state that the approach to quashing convictions in the bill does not set any constitutional precedents. What precedents does the bill set, and why might it be dangerous?
I mean, we may have rehearsed much of this, but any things you want to add to?
This is when I was going to mention Burma Royal, but of course the World War I soldiers. Again, I take the point that there was a statutory pardon, but these are examples. So I don't think it does set a precedent because the Parliament's been able to do this for about 1,000 years.
Okay. Any other observations? No.
I think it sets precedent because it's happened, and I think Roy Jenkins gave a pardon to Timothy Evans after he'd been hanged and explicitly said, I cannot conceive of another situation, the facts are so unique, this will never happen again. And we've had multiple cases where we've had...
Okay. Mr. Haley.
Well, I just wonder whether, I thought that, and I think it was Professor Chalmers that made the point, that when we're talking about the reputation of... We come back to at the start of this, the question of why the DWP cases were not included was considered. And therefore, if it is a reputational issue of the prosecutor, then I can understand why that's the case. However, forgive me, it may have been Professor Chalmers. Professor Chalmers said, this may well not be the prosecutor, but the investigator that is the investigator of the facts that is the crucial matter here. Well, I just wonder that if there is a police officer who is convicted of corruption, which relates completely to the investigation of a number of cases, why on earth would this not set the precedent that every single case, every single one, potentially over a 25-year career, they're not all tainted? And why would you start a blanket precedent to mean that some people who potentially have committed some very
systemic problem requiring a systemic solution, which is what an Act of Parliament is, and trying to deal with something which has undermined the very court system. That's the problem, because in terms of the rule of law, one of the other aspects of the rule of law is entitled to have a fair trial with all of the evidence in front of the jury and in front of the court. And this has been prevented for decades.
I understand that, but the point in the example that I gave, what you are saying is that the act of dishonesty may be in one case or two cases out of a 1,000 case career is sufficient for 998 convictions to be quashed.
I see what I mean. I'm not talking about individuals. There may be all the individuals. I'm talking about a culture that has developed in that prosecution office. That is the thing that needs to be confronted.
That's exactly the same as the West Midlands Serious Crimes Court.
Well, that's the point I was going to make. That's exactly what numerous examples we can show throughout. And there would be a lot of people, on the basis of this precedent, a lot of people who have committed the most serious offences, who could have been convicted on the basis of good evidence, would just have their convictions just quashed.
But that's why we have the CPS, because that's the buffer between the investigator and the court.
No, but you've been making the argument that Parliament should, if it feels appropriate, be able to, and you know, obviously Parliament is sovereign and therefore can essentially do what he wants to do. But I don't think it's correct to say that this doesn't set any precedents.
I think perhaps the best answer to that is that Parliament could, of course, draw a distinction between different groups of cases and take into account the fact there might be people in the circumstances you've described who are very dangerous offenders who are potentially still imprisoned, and that therefore would make it inappropriate to deliberately take almost a rough and ready approach, which would involve consciously quashing convictions of people who might be innocent.
The other point I make is that it gets down to investigation. What you appear to be saying, Dr. Craig, is that the dishonesty as such is the fact that the computer system exists. you are unable, forgive me, I may well be wrong, and if there are cases in respect to this, there are cases whereby the investigative process could have been completely honestly undertaken with good evidence and all of that. And it seems to me a rather strange legal scenario where honest investigation following a proper conviction is tainted because of a computer system that is sort of put into a post office, which might have nothing to do with it.
Absolutely, but that's why Blackstone's principle is quite painful and ugly, and everyone thinks it's a nice idea, but when it actually comes to the rubber meeting the road, it leads to extremely difficult situations like this, which is why it's a systemic solution to a systemic problem. It's why it's incredibly rare, and it's rare because even the Post Office in their latest submission to Sir Wynne Williams said, this is the greatest miscarriage of justice, in their own submissions, the greatest miscarriage of justice in the history of the UK. These are, I think, unique circumstances. That's why that this solution that is being proposed with an Act of Parliament is, in my view, the correct one.
I think we need to make a bit of progress. Did you come, Dr. Quirk, then let's move on very quickly to remaining issues.
Just very briefly, I think this case is exceptional in many ways, but the system is quite capable of dealing with it. We've got a Criminal Cases Review Commission, we've got a Court of Appeal that could process it. I'm not persuaded it needs exceptional measures to overturn these convictions.
Okay, I understand. Somebody suggested you could triage, for example, with rather like Section 31 of the Criminal Appeal Act.
Well, it was done with the shaken baby cases, when, after there was concern about women had been wrongly convicted for killing their babies, I think it was the Solicitor General's office triaged all the cases, and then those that were found to be of concern were sent to the CCRC for further investigation.
Dr. Mullen, Mr. Cherry, and Mr. Seegers.
I want to move on to a slightly different area in terms of accountability for judiciary and the judicial system within this context. And I know others, Dr. Craig, you did early on, have volunteered an absolutely robust defence that this has got nothing to do with the judicial system. And I guess one of the arguments to that is, well, actually, ultimately, it was the Court of Appeal that unpicked that. So therefore, there's nothing to see here. And I just wonder whether any of you might have a different view. I, for example, looked at some of the previous Law Commission work around expert evidence. And if I read from one of their findings, it was that in the absence of a clear legal test to ensure the reliability of expert evidence, advocates do not always cross-examine experts effectively to reveal potential flaws in the expert's methodology, data and reasoning. And I think if you could draw a direct parallel between that finding and potentially some of what's happened in these cases, and whilst the Court of Appeal finding it ultimately is great, would it have been even better if the lower courts actually had managed to understand that? And does it show the necessary humility for the judicial system and however you might, whether it's individuals or system as a whole, to say, well, we've got nothing to learn from this? Anybody? Dr. Quirk,
Dr. Quirk, and then Mr. Joshua.
I've always been very critical of the Court of Appeal and its humility in relation to miscarriages of justice. I'm not sure this is perhaps the best example for criticising them on. But again, I think these are... Professor Andrew Ashworth talked about catalytic cases, where you get the rare case that cuts through into public consciousness, and you can use those cases to make a change. And we've done that for things like abolishing the death penalty or introducing the Police and Criminal Evidence Act. My concern slightly is by making these cases just go away, is we miss an opportunity to look at some of the problems that exist within the criminal justice system, and particularly the appeal system and the Criminal Cases Review Commission. It's a really good opportunity to make the public understand this. So much can be learnt from it, and we miss that if we just make these cases disappear.
Maybe another evidence session coming up.
To Rozenberg.
Yeah, I put this point to the Lady Chief Justice, and she made a couple of points in response. I suggested to her that surely the judges in the Crown Court would have been aware that something was going wrong, so many prosecutions, so many convictions. And she said in response to that point that the judges in different Crown Courts don't really get together and discuss what sort of cases they're dealing with. She said in many cases, defendants pleaded guilty. Now, we all know that why some of them chose to plead guilty, but the courts simply went ahead on the basis that the defendant had pleaded guilty and therefore moved to mitigation and sentencing. For those which were contested, well, the judges take the view that these cases were decided by juries. We're talking mainly about the Crown Court. So the judges don't feel that they did anything particularly wrong, but they do say that they're very willing to do everything they can to put it right.
But if the Lady Chief Justice's attitude is, well, we don't think there's anything for us to learn, what's the mechanism through which that's going to happen? I recognise juries make decisions, but the judge is supposed to be there as a safeguard for due process and making sure the whole thing is fair.
I'm sure she would answer your question by saying that the judges have learned from this. But I think she didn't feel that the judges should be blamed for these miscarriages of justice, given what happened in the courts.
I just say on the point of the mechanical device, there was a long period where defence barristers were saying to the police officer in drink driving cases, prove your machine was working, which is why the statute changed, which has then created the presumption that Horizon was working effectively.
I remember doing exactly that. Probably dates me. But there you go, there's Cherry.
Really, it's rules of evidence rather than the judges who are to blame. But just getting back to this separation of powers thing, I'm starting to be very persuaded by your argument, Dr. Craig, because I think it's true to say, isn't it, that in the United Kingdom there is no strict separation of powers doctrine like there is in some other jurisdictions. But also, isn't the crucial distinction between the way the courts approach things and Parliament approaches things? The courts look at things, the court can only look at the case that comes before it, the individual case, whereas Parliament is in a position to step back and look at to use your words, Dr. Craig, a systemic miscarriage of justice, which seems not to come from so much from what happened in the courts, but more what happened at the back end or the front end of the procedure, something very, very dubious going on in the post office. We don't have time to get into that this afternoon, but certainly many of us feel that these prosecutions were malicious, and so the problem lies with the prosecutor. Possibly a wee bit different in Scotland because we've got the Crown in between, but surely that must be the argument, the answer to the separation of powers argument, that there are certain exceptional, and there won't only be one, doesn't matter if we set a precedent, because there could be other systemic problems in the future, but where it's a systemic problem affecting hundreds of innocent people and destroying lives in the way that we saw, and shocking stuff like a pregnant woman being sent to prison that we've seen on the television for something she hadn't done. That's the justification for Parliament coming in. But I know, because you disagree with me, Dr. Quirk, and I really thought your stuff you've written about this is fantastic, and I'd love you to sort of just encapsulate why what I'm saying is wrong.
Because I think once you start changing the mechanism for certain cases, then it's much more open to abuse. So I could see an argument for all the convictions relating to Partygate or breaches of COVID regulations. That was unfair, and Parliament could legislate to quash those. The minor strike convictions, the Northern Ireland cases, as I've mentioned. I think once you politicise individual convictions, it's a very dangerous road to go down. I think we have a mechanism that works. We should give it the resources to make sure it does so in these cases, because I think it's a terrible cliche, but hard cases and bad law.
That encapsulates the different points of view. It's been very helpfully done. Mr. Stevens, final.
Yeah, thank you. So the final question will start with you, Dr. Craig. I'm thinking about the Glasgow South West constituent who was not convicted but had to beg and borrow to pay back a so-called shortfall from Horizon, which I would call a bogus debt. So there's clearly other issues. So are there other issues that you believe Parliament should consider addressing through legislation as a result of the Horizon scandal?
Let's go around the panel.
Let's go around the panel. The last word will go to Glasgow, as always. Dr. Neil. So we're starting with Dr. Craig.
This catastrophe raises a large number of ancillary cases and issues, and Parliament is seized of the potential future compensation claims that may be coming through. But I'm not across enough detail on the cases where there was no conviction to be making concrete claims about this. One thing I will say, though, which is a little bit unrelated, but it relates to what's really been proven here, is just how much reputation matters in your local community, in the real world, out there in the country. And for me, and this is maybe a low-hanging fruit in some ways because it's got overwhelming public support in the opinion polls, this suggests that maybe all defendants should be anonymous until convicted. which goes to the point about the reputation being affected. But that's a separate point from what.
Interesting. Okay. Very interesting. Very big issue.
I'm conscious of time, so I'll just go through it very quickly. I think you're absolutely right about wrongful accusations, and we need to look at the pressures on suspects for that. The speed that cases are actually dealt with is fundamentally important. People have these accusations hanging over them for years at the moment, waiting for trial. Access to legal aid. If people are on moderate incomes, they may not be eligible for legal aid, which may affect their decisions that they're taking. Pressures to plead guilty. We need to look around issues around plea bargaining, and then the work of the Criminal Cases Review Commission and compensation for those who've been wrongly convicted.
Joshua, to you, because I'm obviously thinking about this from a debt point of view, which may be civil, but is there anything else that Parliament should legislate on in relation to the Horizon scandal?
I'm not sure about legislation, but if you're talking about what your constituents must be saying, and I can say this with the benefit of parliamentary privilege, what an awful lot of people want to see is people from the post office facing criminal charges. Now, even to the extent that people are talking about bringing private prosecutions, which is somewhat ironic. Now, it's obviously right to wait till the end of Sir Win Williams' public inquiry to see what the evidence is. But that's the one thing that the public are looking for, and of course it's the one thing that Parliament shouldn't get involved in.
Thank you. And Professor Chalmers, last word to Glasgow.
I would simply say that the kind of case you mentioned is one that should be addressed through compensation. I'm not, like Dr Craig, on top of enough of the detail of that to answer whether it is adequately addressed at present, but I don't think that requires legislation to answer that problem.
Thank you very much. It's been wide-ranging. I'm very grateful to all of you for your input. It's an unusual session for us to do, but we thought it was important to have this on the record prior to the debate on the bill, which may come back to the House for its committee stage really quite swiftly, for all we know. So I'm immensely grateful to you for your time and your evidence today. We'll conclude this session and we'll swap over to our next panel. Apologies for keeping them waiting. Yeah. Can we just give us... We'll just go...
The proceeding is currently suspended. 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 The proceeding is currently suspended.
Let's resuming our session of the Justice Committee. We're now turning to evidence on an inquiry into the probate system. Grateful to our two witnesses for their patience and for coming to give evidence to us today. All the members, apart from Mr Daly, have made declarations of interest at the beginning of the meeting, which we won't repeat, but Mr Daly, you'd particularly like to make an additional declaration.
I've made a declaration of interest already, but I have to make a fuller declaration
Yes.
in respect of this.
Yes.
So forgive me for reading this out. So I'm a partner in a firm of solicitors, and that firm of solicitors undertakes probate work, and my wife is a probate solicitor.
Important to have that on the record. And perhaps our two witnesses would introduce themselves. Sure.
My name is Jo Summers. I'm a partner in a firm called Jurit LLP, and I'm recently on the Law Society Wills and Equity Committee, and I'm also a spokesperson for STEP, which Society of Trust and Estate Practitioners, which was a bit long, so we shortened it to STEP. So I'm a practitioner dealing with probate.
I'm Stuart Simpson. I'm Head of End of Life Services for a company called Equiniti. We undertake estate administration and probate work for our corporate clients and customers on their behalf. We are registered and licensed by the ICAEW, so we represent those.
Between you, how many sort of probate applications do you think you deal with on an annual basis?
At Equiniti, we do around about 500-600 a year.
We're a lower number because we're at the other end of the scale, so we tend to act for more complicated estates and richer people.
And you've been, I think, both been in practice in the probate area for a number of years?
Yes. More years than I'd like to admit, yes.
Okay. Ballpark terms?
Yeah, you go first.
Sorry?
For around about 7 years, but my team have been involved for over 30 years, some of them as well.
And Jo, you've been specialising in this for?
I started in practice in 1995.
Well, it gives us a flavour of what you're able to say by way of experience. Look, we've had a lot of written evidence in this inquiry, which you may well have seen.
Yes.
What we've picked up seems to be examples of a range of problems being repeatedly raised by practitioners and individuals. Delay, poor communication and error. We've heard that the significant changes happened, I think, back in about 2017, when a number of things came together, changes, and that seemed to have caused a deterioration, and that was pre-pandemic. Is that fair to say?
And I think the pandemic exacerbated that position as well. So not dismissive of the pandemic and the impact that had on working away from the office or the environment.
Yeah.
But I think we would both say that prior to that there was a number of things where the consolidation of the probate courts, bringing them all together under a central solution in Birmingham, and also then winding down the expertise in the local registration had already started causing delays to those applications coming back. And on top of that, the pandemic, things then at that point moved significantly out. And then communication was paused or became less effective at that point in time as well.
I described it as a perfect storm, so you had a number of big changes happening at the same time. So as apart, you're getting away from this localised, where you could speak to people locally, you could get advice from the local registrar,
yes.
Centralised, digitalised, but the digital system doesn't deal with everything.
Yeah.
So there are some paper applications that you have to do, there's some digital, so you've got a twin system, which doesn't work particularly well. Then on top of that, any stressor that you added on, whether it was the probate fees are being announced that they were going to go up, and suddenly you get a deluge of applications, COVID, sadly, more applications. So any stressor that you added to the top of that, just it went over to
in a sense, do I get the sense that the system was being asked to do more than it was capable of digesting it?
Definitely that. So where Joe mentions that there were changes that were implemented, it was a phased approach as well. So that phasing of those, how applications could be made and what could go through the system actually caused confusion as well around what was stopped and what wasn't, what would go through. So that caused delays in the initial timeframes as well. So it is perfect storm is probably a right phrase.
It's been put to me that the advantage of a regional system was that you could ring up if you're a practitioner, you know the people.
Yeah,
and actually
you could get quite a good rapport with the local registrar, and you could cherry pick. So we would have emails go around the office saying Brighton's stacked, don't go to Brighton, go to Winchester this week, and you could almost help HMCTS allocate their workload for them by doing it for them, by going to the one that you knew was less busy. And you could also, if you had a knotty one that you didn't quite know how to deal with, you could ring up and speak to the registrar and say, look, I've got this, what do I need to file? And they could give you guidance. So you could make sure that when your application went in, it was accurate, it met all their requirements. Now you have to send in what you think they might want, it may be stopped, and then you've got to guess from the email that they've sent what it is that they're asking for. Sometimes you misinterpret the email or they misinterpret the reply, and that kind of direct contact is just not there anymore, and it's slowing things down.
I would say I'm not totally against a system. I think the implementation of a system that works, that allows you to contact people in that way or get a accurate and timely response is where we should be moving towards and what we should be aiming for. I think the implementation of it and the way that was delivered is what's caused the problems here, and actually if we could move to that and have better engagement and better dialogue, that would help us much more.
It's been suggested to us that things had improved since September of 2023. Is that your experience or not?
Yes. I mean, we were just saying, we're comparing notes. It's the inconsistency now that's difficult. If a client says to you, how long is it going to take? I do not know what to say to them, because it could come back within 4 weeks, or it could be 4 months, or it could be one of the ones that gets logged somewhere into the system and disappears for another 9 months. I have no way of telling them, none at all, and I've got no way of chasing it when it's disappeared for a long period of time. So it used to be that there was an escalation system. If you'd waited, was it 18 weeks? You could then say, can I please speak to someone to see why I'm still waiting? And effectively you were queue jumping a little bit. I understand why they removed that, because you were getting past the other people in the system. But it means that there is no way now of finding out where along the system you are.
Yeah, I would say that we have. So the figures themselves that are published by HMCTS show that there's improvement. I think the inconsistency of that improvement, I do take it with a level of caution. So there was a big improvement and a big clearing of a backlog in December. Now we know that period is typically a period where there's less applications made. So we see that, so that allows that grace period. Now that we're in the period of the part of the year where applications grow, they are still clearing, but it's at a lesser volume. So in Christmas, over the Christmas period, the number came down the backlog by, they cleared 6,000 more applications than what they received in December. Actually, the past 2 months that have been published, so January, February, that's 2,000 more than they've received. What I would question is, as we go through March and April, and the Easter periods and the bank holidays that are coming up in May, in a busy period, that's typically when they've received more applications than what they've cleared. So do we go back to a period where the backlog starts to grow and things like that? And that's my personal concern, that we are seeing good progress. My other concern is that at no point have we been communicated what that backlog size is. So what did it grow to? I estimate last year that they received 40,000 more applications than they processed, but we don't know how many they had before that period as well. So we don't know what that's grown to. If we had transparency, we could see what that timescales would come down to and around that, but that's one of my concerns, that it starts to grow again.
Yeah, STEP had some figures, and they thought that at one point there was 50,000 in that backlog, then it went down to 40,000. But as you say, that it is not published. And I have asked before, when we've had meetings with HMCTS, if you got rid of that backlog so it wasn't there, would that then make you keep up with everything? Would everything else that now comes in be dealt with quicker? In which case, is there a way of dealing with that backlog? I mean, I jokingly said, can you not get all the old retired registrars, lock them in a hotel room and pay them to be there for the weekend and see how many they can do? Now, I suspect that isn't going to be allowed, but there might be some creative ways that that backlog can be dealt with.
Okay, thanks. That's very helpful to set the scene. Mr. Ali.
In terms of your organisation, how many applications do you submit in paper and how many do you submit online?
Ourselves, a large proportion of paper applications, so you're probably looking 75 to 80% of those paper, and that's because we are, the way we operate, we're a trust organisation, so we make the application as a trust organisation, which means that they have to be made in paper. Because of that, we do see the longer time scales of that as well. So we are impacted by that. Where we can make them online, we do.
Yeah, likewise. We would do everything digital that we can, But the digital process doesn't cover everything we do. So if it's a foreign domiciled person, there's assets outside the UK. We have executors outside the UK who've appointed an attorney, usually me. Then we can't do it on digital. It has to be on paper. Percentage-wise, probably 50-50 between the digital and the paper.
And what's your experience of the Probate registry? How do they differ when dealing with online applications compared to paper applications?
Well, online applications are easier to track because you've got your portal. Paper applications, you don't even get put into the system until somebody's opened the envelope and read it. And it seems to me there's quite a long delay between you sending it from, proving it's been delivered, because you can send it by track delivery, and it actually appearing anywhere in the probate system. And you can call and speak to somebody who says, no, we haven't got it, for weeks.
Yeah, we have an example where it took 3 weeks from date of receipt on raw mail special delivery to the date of it appearing on the system as starting to process. When we queried that, we were told that it is the point at the application is starting to be processed, is the point that starts the 16 weeks ticking. Yeah. At that point, we can't make a query about that until 16 weeks. So you then have you're looking more at the 20 weeks. If I turn that around to the members of the public, and that's not commonly known, they won't get spoken to in that. You may have people that are vulnerable wanting to understand that. Would just like to come back from a member of the public position on paper versus public. I do have, from sort of my personal view of this, is there a digital exclusion of those people that if you don't have access to a computer, you cannot make it, or you're not computer literate, or you have a disability that means that you would prefer to use paper? Are we disadvantaged, or are those people disadvantaged because of the timescales that are there? And it is weeks in that position as well.
Yes, and it seems that quite a lot of the people who do probates themselves prefer to do it on paper.
They do, yeah.
Thank you.
Mr. Daly.
Joe, you very openly confirmed your vast experience in this field of work.
Yes. I can't deny it, yes.
And we're very grateful for your expertise in respect of that. Can I ask you, if you go back to when you were dealing with your local probate registry and you were applying for probate on behalf of a client, in general terms, how long did it take, the process?
About 4 weeks.
Okay. And so as a result, we can blame lots of things, but let's just say that the problem at the probate registry got so bad, was so exacerbated, we'll say, that an application that previously had taken approximately 4 weeks would take how long?
What now?
Well, at its worst, if I can put it like that, there's been I think we have to say there has been some progress recently from the probate registry. But I just wanted to see, the thing is, 4 weeks seemed to me to be a perfectly reasonable amount of time for a process to take place. So on the face of it, we know that the system can work and it can do within 4 weeks. We've invented a system that's created problems for a system that worked perfectly well.
Yes, it wasn't broken. Why did we fix it? Yes.
Exactly. So as a result of this, we are, as a committee, looking for helpful suggestions to have a more efficient system in terms of how we deal with it. And I just wonder, you sort of answered these questions already, but how do we get back to that 4 week process, do you think?
So I think we need better communication. There needs to be a way of talking to the person who's actually handling your case, not to somebody who's reading something on a system who has no knowledge necessarily of the question you're asking. So, for example, if you ring up and try to speak to somebody at the probate registry, it's now only mornings, and you've got a web chat facility as well, but the person who's answering that may have absolutely no knowledge of what your question is, or how to answer it, or how to give you any guidance. So they are literally just somebody who's answering the call. When we were able to speak directly to the registrar, you could get real progress within 5 minutes. And I had an example recently where we had to get an emergency grant on one asset in an estate on behalf of a creditor, which is a little unusual. And it was a long time since I'd done one of those. And in the old days, I'd have picked up the phone and said, oh, whoever I was talking, can you remind me what I do here, please? But this one, we actually found somebody in the Cardiff registry, which was unusual because I didn't think they were still around, who was willing to speak to the registrar for us, but it was like Chinese whispers.
So I'm going to say something that will horrify just about every member of Parliament, this committee, and probably the world at large. Why don't we go back to the old system?
I don't know. I'd love to.
And just do it, and just go back. It's amazing that as politicians we invent systems that don't work, then look at ways to carry on systems that don't work. Whereas actually, the process that happened before, we would have to quantify the cost of that. But I think the point that both of you would make, and please don't let me put, is that it was a system that worked. It gave reassurance to people who were taking part in it, and it was done in a timely, efficient manner.
If I can just come back on that. So, absolutely. So, 4 weeks was what we are at our worst point. We still 30 weeks on applications. On average, we were at 24 weeks. So you're looking at
4 weeks to 24 weeks.
Yes, so 6 times the length.
And we've had some that are a bit longer than that because they were foreign ones that had a bit more difficulty to them. So I think the worst one we had was 8 months.
And if on the timescales, James, if I can answer that, I think the system does work. So I work in an organisation where we have large systems and we're able, a customer experience centre, people contact us. For the non-complex things, that would be absolutely perfect. I think for Joe, where there's complex, where we cannot get to speak to somebody who knows about our case, those are the issues. And when you receive a message back saying, until you get to 16 weeks, you cannot engage with us about that case in any way, that is the challenge that we have, because we can't then communicate to our customers or the public what's happening with that.
I've got 2 further quick questions, if that's okay. And I'm going to describe this inadequately. There is a third party who is involved sometimes in the process, which certain documentation has to be sent to be certified. Is this correct? There is a... Forgive me, I'm not being very, very articulate about this.
You're talking about HMRC?
No, in terms of the... And colleagues will probably help me in respect to this, but in terms of the documents that support a probate application, the original versions of those documents, if they are financial documents, where are they sent to?
So even if you apply online, digitally, you have to post in the original will. And any other documents like a codicil or anything else that's related to it. So they have to go in physically, yes.
And they go into the registry, or do they go elsewhere?
They all get sent to Newcastle, don't they?
I believe that there's a scanning area around.
Yes, so you send it to a separate organisation who...
You send it to HMCTS. I think they pass it on to the scanners.
They pass it on. And in terms of that relationship with the scanners, if I can put it that way, do you have any views on that, about whether that causes delay or problems? Or I would imagine that documents may have a habit of being lost from time to time and various...
We've heard some horror stories. It's not happened to me, luckily. I have had the classic scanning error of a stop on my probate application because I'd sent in an incomplete will and it was pages 1357 and someone hadn't scanned both sides. So you do get scanning errors. It's human nature. If you're doing a rather tedious job of scanning in however many wills per day, I'm not sure that you're going to be paying a huge amount of attention.
Can I just use you? Is there a way that process could be done by you rather than it having to be sent from the the probate registry to a third party?
You probably could, yeah. So there's different ways. On small scale, local scanning, large in-house, we have large scale scanning that allows us to do that. I do sort of Joe's point of scanning, not scanning 2 sides. That should, if they've got large scale scanning, that should never happen. But yeah, I think it could be done in that. Like you, we've not seen examples of things being lost in large scales or anything like that. The only question I have about it is that the cause of the time delays between it being received in the post and then cases being stopped 2 or 3 days later? We've got no evidence of that, or I can't say that I've got evidence, so that's anecdotal.
So last question, because colleagues will want to come in. The Probate Registry has changed its working practices to avoid incentivising staff to stop a case. Have you noticed any changes in the number of unnecessary stops since autumn 2023?
I think we have seen fewer stops. I understand what happened before was if it looked too tricky, it was very tempting to put it on the stop pile because it went somewhere else. Yeah. And what they've done now is it comes back to the same team to deal with it. So if you stopped it, you get it back. So you are now more likely to look at it the first time around because you know it's coming back to you. And I think we have seen a few less stops, or we've had a couple of instances where we've had emails saying, I think we need this, but we don't seem to have it. Or, something that shows they've actually read it rather than just put a stop on it, yes.
I'm not hearing anything material, if I'm honest. So it's still,
You might just
No
ask you to
bits.
speak up.
Sorry, sorry.
Just when you're facing away from the mic.
Quietly
it
spoken.
doesn't
Sorry
pick up
about
so
that.
easily.
So yeah,
That's all.
I'm not hearing anything that is too different from where we were before. Sorry about that.
That's okay.
Thank you very much, Chair.
Thanks very much. Dr. Munn.
Just to begin with, I just want to pick up on the points that you're making about the telephone conversations. So is it the case that it's literally no mechanism at all for you to have a discussion now through formal channels with someone who's dealing with your case who actually is a registrar? Or just that it's way more difficult to get to that? Or it just
Until very, very recently, there was no way of speaking to the registrar. HMCTS, within the last few weeks, instigated a trial of having some online surgeries, might be a good word, where a registrar or senior person would appear and you could book your slot to talk about case number whatever. Right. And as you can imagine, those slots disappeared almost instantly. Right. And I think if that trial could be continued, that would resolve some of the problems we've been saying. And I would very much support that happening.
Thank you. So the next question I want to ask then is about the reform to the process in terms of the necessity to have a HMRC, the estate code, etc., to prove that you've done that side of things. Do you think that's been a positive change or a negative change? Whether you've got any reflections on that?
Teething problems, I think. Right. I understand entirely why they did it. People were trying to buck the system by applying too early, which wasn't working. And we were trying to get out to all our members, both at Law Society and STEP, don't do this because you're actually going to take longer. But I think it's human nature. There's always somebody who's going to do that and think it's going to work. So I understand entirely why they want to make sure you've done the HMRC process first. But what they didn't appreciate, and I don't know if this is the same for you, is that normally a practitioner, when you meet your clients, you will take into that one meeting all the documents you need them to sign. Here, sign this, and then you've only need one meeting. And particularly if you've got to collect loads of people in from different places. And now you can't create the probate application document without the code. So does that mean you need 2 meetings? Or do you have to circulate things twice? Yeah. And there have been a lot of complaints about that, because if there was only a way of creating it but with a gap for the code draft to go in, a draft, get that signed. The answer is, actually, you don't need the client to sign all the documents. The IHT 400 can be sent in by an agent, us, on behalf of the client. I can do the same with IHT 100 for trust, and I can just put in my letter, it's been seen and approved. But most practitioners are really reluctant to do that. They kind of feel that it's better for the client to sign it. It shows that they've seen it, they've read it. They can't say, oh, I didn't see anything. Their signature's on it. And I do think that lawyers in particular, maybe not so much, I don't know, maybe you guys as well, we're reluctant to change. And this idea of having to have more than one meeting, it's not gone down well at all.
So if the system were to allow you to do everything that you need to do except literally click the submit button without that code, that would be more effective?
Yes.
I think we're slightly different. We operate as administrators as well. So actually the executors give that power over to ourselves to sign on their behalf. Right. So that means that actually we don't see some of the problems that Joe's mentioned. From HMRC's perspective, what we have seen is a consistency of those responses coming back. So it does take around about 3 weeks. That makes it a 4-week before we can make the grant of probate application. But what I would say is that time from application to receipt has been relatively consistent. So across my team, we're getting good feedback. Actually, we did look into it as slight sort of concern of what is this going to do on top of what's happening. Actually, we've been pleasantly surprised, I think, in that it hasn't caused a longer delay to these things.
Whereas I've had some feedback from a former colleague of mine saying that she thinks HMRC need chasing on a regular basis. It obviously seems a bit patchy.
Okay, and then we mentioned the phone lines. The decision to cut the afternoon availability of the phone lines, what impact has that had, and do you think that's been a good measure that should continue?
I think it did work. My first initial reaction was, they're even trying not to talk to us on the phone now. But they kept the web chat, and it was announced, so you knew you just had to call in the morning. And the feedback I've got is that it hasn't extended the time it takes to get someone on the phone to pick up, which is useful. And it has seemed to reallocate people. And ironically, HMCTS were looking for somebody to say, yes, we think this is a good thing, and they came to me as one of the people, and I said, in an ideal world, you'd have enough people to do both. but I understand you don't. So I think it has been a good allocation of resources.
Okay, anything to add?
I agree with the allocation of resources. I think actually as practitioners it has an impact on us. It has changed our working practices. It does mean then that a number of my colleagues come in and the first thing they do is make the phone calls and things. That changes our working day and our practices around that. I then think actually if you think more about the public, if you are constricting to during the working day, actually we are not supporting the individual members of the public. So thinking more broadly than ourselves as practitioners, I don't think it's positive or sustainable on a long-term position from that perspective.
Because you'd always have to do your probate stuff in the morning, always.
Yeah. Or if you're a member of the public, you have to phone up during your lunchtime. That's their busy hours. So then you are waiting for those calls. You don't get that opportunity to make those calls at other times.
All right, thank you.
Simpson.
Thank you, Chair. Can we go back to the issue of delays and the seemingly large amount of lack of transparency around both the compounded backlog of cases but also how long applications are taking to process? And really trying to look at it from two angles. First of all, from bereaved families who are waiting for closure and the outcome, but also from practitioners and professional firms. Dealing first of all with bereaved families, are there any experience you can share of how delays have had impact or any evidence that you've managed to accumulate through the work that you've done that demonstrates the sorts of impact that it's having on bereaved families when there is a delay which no one really knows how long it's going to be?
Yeah, and particularly house sales. If you've got an estate with a property in it, mum was living it with dad, dad died, mum's died, it's an empty property. And you don't know how long it's going to be before you can sell it because you have no idea how long it's going to take to get probate. And you've suddenly got to have unoccupied property insurance because the insurance company won't cover it. You end up paying for property managers to go in because or the family have to take that job. And you see the property prices going down. So if you'd sold it last week, you'd have got this much, and next month it'll be less. That's a really tricky thing to help a family through. I mean, I'm lucky. I don't deal with people where they've got real financial need. They're starving. I haven't got that kind of client base. But I see people where they've had to take out money to borrow to pay the inheritance tax, and they're paying interest for that whole period that they're waiting for that. And interest rates are going up, generally speaking, so they're paying more. So we are seeing real financial problems, people who can't access portfolios. And they would have sold it because it's all going down, and they're losing however much on that. So yes, it's not been pretty.
Yeah, I would echo all of that, but I would say there are. So my view, and sort of said this to Kate before, is the not everybody who inherits from an estate is wealthy at the outset. They are not all those people that had the wealth that passed on to them. We do have customers who, and we had a case this winter during the economic crisis and the cost of living crisis, where a gentleman gave us a call and said, is there any way that you can release funds before you get probate because my mum can't turn on the heating? Those type of things. So and legally there isn't, until we've got probate, we don't have the legal authority to distribute those funds. So then you're in a do we lend money? How do you go through those? So from a customer service or a customer care position and vulnerable customer, is managing those and managing the expectations of individuals who, particularly, say, I've spoken to my friend down the pub. Oh, it only took us when mum died, it only took 5 weeks to get probate. Now it's taking such a long period of time, and actually they don't have those funds. We have seen, not in lots of cases, but those property sales where wrongly, in a way, the family have put the property up for sale, but it doesn't then just have an impact on the beneficiaries of the estate. Where that chain collapses, that has another knock-on effect. If you think about the whole economy, it can knock down and lose those as well. So I think more broadly about what we're looking at here, vulnerable customers and that crisis, people taking out loans that they just have never taken out and have an open end to them in a period effectively until probate's there and they can pay those inheritance tax loans off. And we have seen some individuals, unfortunately, because of the delays, then had to pay more inheritance tax because the timescales have took them over a threshold. And those are the knock-ons that I think are unfair, particularly when it's not through the individuals doing it, it's not avoidance, it is because of the situation that is out there.
And HMRC is still sticking to their normal deadlines, as if there's been no change.
Yeah.
So you're still required to do everything just as you did before. So whether it takes 4 weeks or 4 months or a year, HMRC doesn't change anything.
And what consequences does that have on you as practitioners and trying to run a professional firm where there may be a squeezed timeline, but also you may be getting more complaints about the probate system, that you're in the dark about how long each application is going to take? How's that affected your own working environment and the way that you have to operate and how you allocate resources?
Well, it's tricky. I mean, the hardest bit is when a client says how long is it going to take and you literally do not know what to say. I mean, how long's a piece of string isn't a good answer, but it's the only answer I've got right now. I mean, I was saying just before I came in, if you could say guaranteed it would be 8 weeks, it's not as good as it used to be, but we could all have some consistency and we could all tell clients that's what to expect. But we literally don't know. A colleague of mine said that they got one application back within 2 weeks. So that's quicker than any we've had. It doesn't seem to be any consistency as to how they're being dealt with at the other end. They don't seem to be in date order, because somebody who's applied after me gets done first. I don't understand that. So the hardest thing is the communication with the client, because we don't know what to say to them.
Do you think it would be helpful, and this has been submitted to us by other professionals working in probate through their written evidence, that if there were minimum service levels for the probate registry that were introduced to try and provide some certainty about exactly what both you as well as the families who are coming into contact with the service would expect at the very least, including timescales and the processing of their application.
In private industry, I'm very used to having KPIs, key performance indicators and minimum service standards and things like that. If we don't adhere to those, some of our corporate contracts have penalties against them. I don't think you have to go into penalties, but actually why can't we have that level of standard and commitment? And just going back to your early question around that would the impact that we've seen is a disinformation, so if I can call it that, where HMCTS have put out their information of what their delivery and their timescales are
on their website.
And we see very different timescales. I've had my staff called liars in the back of saying, actually, we trust the civil service, we trust HMCTS, you're telling us different and things like that. And that has an emotional effect on people that are professionals and things like that. So just to go back to that, but I think those minimum service standards that we could all say, yes, this is where it is, it's in the public domain, everybody knows about it. Actually, that's one of my things that I would say absolutely is a key for us to get out of.
Is that something that's been thrown out there before? Is this a new idea, or have you been sort of waiting for this for a long time?
You had the 18 weeks, and then you could use the kind of acceleration service, and that was abolished by HMCTS. They removed it. So we've actually gone the other way. We've gone away from having any kind of deadline that they have to stick to. I mean, as a solicitor, I could be hauled before my regulator if I have undue delays on many, many clients. You know, if I was just saying lackadaisical and everything, they could complain. There's an ombudsman, there's a regulator. I've got nothing. I have nothing I can do to force HMCTS to look at an application that I sent in 25 weeks ago or whatever. There's nothing I can do.
And I don't think when you look back 5 years ago when we were getting them in 4 to 6 weeks, actually that was consistent. But we didn't think that you needed a service level to achieve. Now, because of where we are, I think that standard would be really helpful.
Yeah.
Thank you. Thanks very much. I'm just interested in another point here. STEP have produced some evidence, and a number of other people as well, about the delays encouraging folk to perhaps go to unregulated providers, offering online and other things. What's the extent of that problem, do you think?
So we've seen people popping up advertising products that they say avoids probate delays because it avoids the need for probate. And ironically, America has the similar system. There's quite a few techniques in America they use to avoid probate, in some states more than others. And they generally involve setting up a trust, putting your own assets into trust, and then they're owned by a trustee rather than you when you die, so you don't need probate. They completely ignore a number of major things like tax. And frequently they are creating tax liabilities that they have no knowledge of. And it's a particular bugbear of mine that anybody can set themselves up as a trust or tax advisor without any regulation whatsoever. Your plumber could do it tomorrow if they fancied it. They probably make less money than plumbing, but you know. So it's a Wild West of people who can just pop up with these fancy schemes, and they all seem to be pretty much of a muchness when you actually read through them.
I think my concern as well is that the people that will go to those are those people that are in a vulnerable position again and want to access the funds from the estate as quickly as possible, and may not have the knowledge of the implications of what they're undertaking. So if they do that and the risk that they're doing that, you are opening up to potential fraud and things that go with that.
What would you suggest to us is the solution to that? Is it a regulatory one? Should they be brought within a regulatory framework, or is there more we can do in terms of consumer protection and education?
Mixture, maybe. I mean, education, definitely. It's one of the things that we always try and make sure that clients understand that if it sounds too good to be true, it is. But also, I think there may be an argument eventually for regulation of all these things, but that's not going to stop the probate delays. The quickest solution would be to make sure there's no probate delays. That would remove all the need for these.
I was thinking exactly the same. If you remove that issue, people don't seize the opportunity to step into a market that's been created.
I mean, going back to the points that Mr. Daly was raising, I mean, and scanning and so forth, some been suggested to us, well, wouldn't it be possible for the solicitors, for example, to scan and certify that you've got a copy?
We did suggest that right at the start, and HMCTS said that our scanners weren't going to be good enough. But I think in this day and age, if they could come up with minimum requirements for, it's got to be a JPEG or a PDF, it's got to be this quality or that, we could meet that. And I'm sure you guys probably could.
Yeah, and I think if we are asking regulated or licensed people to authenticate that document is real, if they are using DocuSign or DigiSign or something that says, I have seen this document and I am personally responsible that I've put my name against it. I think we heard in the previous session that there may be unscrupulous people, but they would be much fewer. And actually, it's our livelihoods that we would lose if we
and then you would
retain, you wouldn't do that.
You or the client would retain the original.
Yes.
For inspection if needed, perhaps.
For audit purposes, you could come back and say, actually, we want to audit this document. Please, could you send the original to us?
Which, ironically, would deal with another consultation that HMCTS has out about shredding wills and not storing the originals, because they've got however many hundreds of thousands of wills in storage. I mean, they would be in our storage rather than theirs if we went down this route.
That's interesting point. You talked about sort of vulnerable clients sometimes, those who might be financially vulnerable, for example, or pushed to go into that sector for those reasons. What about the general treatment of people who are dealing with this when they've lost a loved one, could be under very tragic circumstances in certain instances, or they may be vulnerable for health reasons, disabled or whatever. What's your assessment? I know, Stuart, you're the executive sponsor in your organisation for dealing with vulnerable people. Well, what's your assessment of the way the probate registry does or doesn't handle people in that sort of situation?
I think my views around it is those, as I mentioned, the bringing in of the contact centre times doesn't take into the needs of the customer. Digitally excluded people aren't thought. So we're driving. I do agree with digitalisation as a general principle, moving towards that, but bringing those people and not offering or seemingly penalising those people that do paper applications through that is a challenge. I think if you are trying to get hold of the customer service centre or their contact centre and you aren't able to do that, if you have a situation where we know that you keep trying or you try and escalate it, if you aren't somebody that's used to this situation, and I've spoke with people who are extremely competent, finance directors and things, but actually having gone through a bereavement, have just said, I don't want to deal with that day to day, managing the affairs of somebody I love, and also the concern that I am dealing with an estate on behalf of my family and friends. So I've got the responsibility for that. That adds an extra pressure. If you then can't respond to their queries in a period of time because you can't get through to a contact centre to answer that, I think at a fundamental level of somebody who's bereaved, that is a challenge around vulnerability and sort of how you do that. You then take that forward into somebody who has a disability in a wider sense around that, or a reliance on somebody. So we have seen people that the main income earner in that relationship has passed away, but they can't receive the funds that they need to live on because actually they're locked up in until you've got probate, or they haven't transferred over. Those are the things that if that person is vulnerable for health or financial reasons at that point, again, the lengthy delays only exacerbate that problem and can cause concern and things like that. So I spoke to, thankfully we get very few, but we have had people that have contacted us say, I'm suicidal and I have thoughts around how do I live. Because of the delays, I can't get the funds that I need and things like that. So fortunately we do, our teams are trained in that. We do train people in to deal with those things, but that is, it is an ongoing concern. We do get those come through as well.
And when you go back to the probate registry in a case like that, they come to you and your team are trying to help them, calm them, if you like, reassure them. You go to the probate registry, look, here's what sort of response do you get? Do they understand it or not?
I would say this. If you go through to the contact centre line, no. If you use the web chat, very much no. It is stock answers that come back to you.
You wonder if it's AI, don't you?
Yes, and maybe it is. And again, there's not a bad thing sometimes around that. But I think we found one of the probate courts with an individual that was really helpful to us, and we have selectively used that in a small number of cases to say we need to escalate because there are certain circumstances that we need to do that. Actually, once you've got those individuals, they're really helpful. Yeah, I can't say, but it goes back to sort of going, there is a systemic position that sits behind it that needs addressing for us to have that consistent approach. And if there is an escalation at the moment, we are told for those cases where we are acting as a trust, because they are stopped under that, we cannot escalate them. So we can't even have that conversation to say there is a very vulnerable person that sits behind it, because as soon as we say the case reference, our conversation is stopped at that point until we get to the 16-week point.
Yeah, it's a different team that deals with your applications.
Yes.
Yeah. And I think also there is an access to justice issue, because if you're saying digital applications are going to go through quicker, that's forcing people to get legal advice or to go to a licensed probate practitioner or lawyer, whereas otherwise they could do it themselves. So anybody who's doing it themselves is likely to be doing it on paper, and that feels like you're disadvantaging them.
You're forced, because they may not have the digital skills, they're being forced into the customer representation.
And it is the most traumatic time that you're going to be dealing with these people. So, we always have the box of tissues in the office for when somebody's crying. But, yes, it's really tough. They've just lost somebody, and then they've got all of this on top. It is the worst possible time to be kicking them when they're down with probate delays.
We do get the other side as well, actually, those people that aren't connected, but they want the money really quickly, and that actually can have a different... They're easy to understand those, and they're not vulnerable people, but actually they want the money quicker and things like that. And I know that you've already spoken to the charities. There is a big impact on charities, on their funding and things that they've had.
Yeah, absolutely.
Thank you, Mr. Simpson.
Thank you, Chair. One of the core purposes of doing this inquiry and having these evidence sessions is, believe it or not, to try and be helpful to the government and to those working in probate, and particularly the probate registry, and try and find and offer solutions to some of the problems and challenges that they're facing, not least the backlog, and trying to get on top of a much more efficient and reliable system that we can have confidence in. And earlier, Joe, you mentioned, I wouldn't quite say as a throwaway comment, but you floated the idea of retired registrars coming back to help with that. But there's something in it, and the suggestion that I think you've also said around secondments, but also outsourcing. at least in the short term, to try and help deal with the backlog. Could you perhaps just say a little bit more about how you think that might work in practice and what it would entail?
I have been approached because of my work with STEP by a few practitioners saying, where do I volunteer to help? And they will have a different variety of motives. Some will be doing it because they think there's a bit of kudos involved. Some will be doing it because they're hoping their application is the one that they get to look at and they can clear. But generally speaking, it's because people want to help. And if there is a way of a whole pile of experienced probate lawyers all rolling their sleeves up together and going in and helping out, they would do it. And I don't know what the cost of that would be, if any, but certainly if you could get rid of that backlog, I think the system would work pretty much, unless they do something else like announce they're going to increase the probate fees again. I think the system as it is would work well without that backlog. And then your waiting times would come down considerably because you wouldn't be doing it, the old ones.
I do think actually the system is probably in a better position than it was, but it is the backlog that you work around and things like that. I think if it was my organisation, I wouldn't be too fond of lots of people coming in and offering their help, but that may be a way around it. I think it's actually giving the resource and bringing that in and making sure that the resources are allocated in an appropriate way. One of the challenges that I see around the communication from last year was we were consistently told that HMCCFs were recruiting 100 new staff. Actually, under digging behind that, it wasn't 100 new staff. It was 60 staff that were new, 40 to replace headcount that had been lost. And actually, these weren't qualified staff. These were people that were to take phone calls. So actually, you exacerbate the problem. If you bring in qualified people to remove the backlog, that is my view of saying, actually, let's put the right resource in the right area to address the problem. It's not about headcount. It's not about numbers of seats on bums or bums on seats. That's helpful. Actually, it's saying, have we got the right people in the right place to be able to do that? And again, I think we are all in sort of agreement that actually fair communication, we don't need this to go back to 2 weeks or 4 weeks. What we need is consistent delivery and actually on that timescale of things coming through. So I'm not answering your question directly, Edward, but it's sort of that saying that we want to see progress. So yes, people going in, rightly qualified, either ex-staff from the registries or opening them up for a time period where they are capable to do that, to clear that backlog and then reset the marker would be a really good position for us, I think.
Would one of the other benefits of that being opening up, whether it's the charitable sector, the private sector, to bring that resource in, that there would be potential experience in there to deal with some of the more complex cases, which often take up quite a lot of the capacity within the registry?
Yes, I would expect so. I mean, I would think that somebody sort of my end who deals with the international side, I will know how to deal with something much quicker than somebody who's never seen one before, just by dint of experience. So I think that if you can get people in who've got that kind of experience, then that will make a huge difference. I mean, you were talking about the 100 new employees that they'd hired. The other thing you had to bear in mind was that in order to train them, it was the existing people who were having to train them. There was nobody coming in from outside. Yeah. So taking 100 new people took people away from doing the applications because they were training those people. So there was actually a time when that new staff made it worse before it started making it better again. So you've got to think about these. Who are the people, and getting the right people.
And I think, again, I accept that there's a time lag on these things, so bringing them in training and doing that. But if we understand that timescales to say, actually, at this point in time, we'll see an improvement, I don't think that was clearly communicated last year. We are seeing those improvements come through, but they need to be much better and consistent and give us that confidence that it's going to be maintained, I guess.
Yeah. I mean, at the moment, it's almost like a professional jealousy reading. Someone said, I got mine back in 9 days. How did you do that? Well, I know not there. Yeah, so you end up with lots of people comparing notes, and we've no clue as to why that one was dealt with quicker than that one. None.
It was 7 days in Singapore, wasn't it? Yeah. Thank you.
You've given us a number of suggestions as to how these could be improved. I get the sense you mentioned some family and friends, Stuart, earlier on. Would you be happy letting people family and friends, either of you, navigate the system without professional help at the moment?
Oh gosh, no.
No.
That's very clear.
Something happened to my dad, I wouldn't let my mum do probate. Gosh, no. No, I'd get one of my paralegals to do it.
I'm named executor and probably would ask somebody else to do it for me.
Yeah.
No, that's very point. That's very point. Are there any other suggestions you'd like us to make to us that we haven't covered?
There is one point, which is we do occasionally get somebody who comes to us and they've started doing probate by themselves, hadn't appreciated quite how hard it was going to be, come up against this wall of, oh my God, where's it gone in the probate registry? I've got no answer. And they come to us and ask us, can we take over their case? And at the current time, unless it's changed recently, we can't. And if we ring up about a layperson's application, HMCTS won't talk to us because it's not our application. So we can't get any more information out of them. We can't pass it on. It's crazy.
Yes.
And you could send them a letter authorising on
Yeah,
that.
we could. Yeah, you get the client to sign an engagement letter.
Exactly,
you do all the normal things of getting passports and utility bills. But
I'm guessing you do them. Your involvement in a case, I assume, probably makes it go slightly more quickly than if a layperson does it. It's in their interest to have you step in.
Yeah.
Got a sense of scale of how many of those sorts of cases there are?
Don't know how many. I mean, we've had a few. We've just basically given them some advice rather than trying to take over because we know we can't. If you times that by however many law firms there are out there, I guess each law firm's probably coming across a few. I know because being with STEP, I was on radio and there was a call in for you and yours, and the number of people who called in saying, I've been trying to get probate and I haven't got anywhere. The phone lines were jammed apparently. They only put a few of the calls through. So it's a big thing, I think. Yeah.
If you're a lay executor, you're financially and legally responsible for it. So if you get it wrong, it can come back years and years later that you have to pay that. That is...
Yeah,
that's the point around that. So
liability, yeah.
It doesn't have to be a professional, but just the individual has to have the support to get it right.
I have actually asked HMCTS, because the other thing is a lot of people don't know when you need probate. And part of the problem is that banks often have different rules of how much they'll release without probate, what they call their sort of small funds limits. They sometimes vary. And I've asked HMCTS, and they do get quite a few calls of people saying, so-and-so's died, aunt, whatever, do I need probate? If there was a different way of those calls being dealt with, that wasn't at HMCTS or at the probate registry, so that they can just deal with the probate applications that they've actually got to deal with, not somebody ringing up finding out if they do or don't need probate.
What different way might you use for that?
Well, there is the Tell Me Once on .gov.uk. If there could be something tied to that saying, do I need probate, click here. Web chat or phone or whatever.
The Gov.uk website I find quite helpful.
Yeah.
It's really good.
We direct
but actually people to find that, so better signposting of that for the public would be really helpful. And it is that, do I need probate, what does that mean, and where does that fit in? I think I agree with that.
Yeah.
Okay, that's very useful. Do any of my colleagues have any other questions? Anything else that you think we've missed, or have we?
No, I think we're there. Sorry, there was one question. We have had some instances where MPs may have stepped forward to offer support and things. I would just like to say, I have mixed views around that, if I'm honest. Sometimes it's helped them jump the queue. Sometimes I think that we've seen individuals come to us with that, and just by quirk of timing, it is the point where the grant of probate, because they've got to the point to raise an issue with their MP, it is so far down the line that actually the probate's coming back. We had one where an MP phoned us one day and miraculously the grant appeared the next day in our postbag.
Yes.
And you've just,
Not
that's
entirely
exactly
sure
that.
it was the MP's involvement.
No,
maybe.
And it's sort of...
None of us
so
have
actually,
any egos.
And I think it's that, just say, actually, the best thing would be if we all had a standard of saying, actually, a timeliness so we could deliver through, get it right, and then actually it means that you guys don't have to be involved in it from that perspective.
Well, that's very helpful. Well, look, thank you very much for taking the time and trouble to come and give evidence to us. That's been very useful indeed. We covered a good bit of ground there. If you do think of anything else, don't hesitate to send in any further written evidence. We're also open to that. And thanks also for your patience while we dealt with the other matter that we had to do.
That's right, we were interested in listening in.
It was interesting, wasn't it? Interesting, wasn't it? I think that's absolutely right. Well, so the session is concluded.
Thank you.
Order.
Thank you for your time.
Portcullis House. The proceeding has ended. The proceeding has ended. The proceeding has ended.